this evening we shall be having a discussion around the Computer Misuse and Cybercrimes Amendment Act, as well as the Privatization Act. And joining us in this very interesting conversation, we have Levi Munyeri, who is a wakili at and he's an advocate of the High Court of Kenya, and he has a law firm, Kimani Kiari and Associates. Karibu sana wakili. Clap for wakili tafadhali. We also have Wakili Evans Ogada, who is an advocate of the High Court of Kenya, as well as a part-time lecturer and a researcher. Makofi kwake. We have Ray Ondaga, an advocate of the High Court of Kenya, and legal researcher at Katiba Institute. Let's clap for them. So before we start, I just want to hear from you. How many of us have heard about those two laws? The Computer Misuse and Cyber Amendment Act and the Privatization Act of 2025. How many have heard about those two laws? By a show of hands. All right. So what have you heard? What have you heard about these two laws? Just stand up and say what you have heard. Yes, madam. Kindly stand. There's a microphone. There's a microphone.
What I've seen on Twitter is if your post hurt someone's feelings, you're going to be charged 20 million.
What else have we heard? Yes, sir.
Okay, I've heard something about Computer Misuse and Cybercrime Act, where the politicians have their version and the people also have their version. Yes.
Okay. Yes. Two more voices in the room. What have we heard? Yes. Pass the microphone.
Yes. Hi. I've heard about the Privatization Act. I've heard that it takes the power to sell state corporations from the MPs in Parliament to directly through Treasury. So from the MPs to the executive.
Okay. Last but not least. One more voice in the room at the back. Okay. So, of course, we have a lot of information surrounding these two particular laws, and we shall begin by having a discussion around the Computer Misuse and Cyber Amendment Act of 2025. And the first question will be posed to Wakili Levi Munyeri. Wakili, this Principal Act, kindly take us through the recent amendments. Take us through the good, the bad, and the ugly of the recent amendments of the Computer Misuse and the Cybercrimes Amendment Act. Karibu sana wakili.
Thank you so much. It's a great thing to be here today. This is a very amazing scene I'm seeing. At this time of the night, all of us are here, united in patriotism and care for our nation. I'm happy to be here. As you've heard, my name is Munyeri Levi. I'm an advocate of the High Court of Kenya. But most important, like all of you, I'm a very patriotic citizen. And that's the core reason I'm here today. As one of you has mentioned, there's a lot of controversy in terms of content of the Computer Misuse and Cybercrimes Act. That is an amendment. It was the amendment bill, is now the Amendment Act, enacted on 15th of October after the passing on of Raila Odinga. First things first, let me address two critical issues. One of my panelists here is a professor. He's always shy to say he's a professor. I'm very honored to be with you here today, Professor, one of the finest constitutional lawyers we have in this country, which will make me a little bit shy as I address the legal issues. First thing first, I'll first spend a minute or two to answer a very critical question that have been asked in different platforms. That question is, what is the role of lawyers in terms of challenging laws that have been enacted? This question stems from a very important principle we call separation of powers, that the government is actually has branches, being three major branches. One is the executive, that is the presidency. Second is the legislature, which is parliament enacting laws. And third is the judiciary. People have asked questions, why should you wait until and bill actually is enacted into law before you go to court to challenge it. There is a very important reason. It's because the law acknowledges that there is a separation between the judiciary and the legislature. The core function of the legislature is to enact laws. The core function of the judiciary is actually to interpret laws. Save for very narrow situations, it has actually happened once or twice in my practice of law, is you can challenge a law during the legislative process that has actually been explained here so well. So as lawyers, we can only come in after the president has assented the law, in that the judiciary is not expected to interfere with the functions of parliament in terms of legislation. So that is very important, so that you don't blame or fault lawyers like ourselves for waiting until a law is enacted and signed by the president before you go to the High Court to challenge. There is a very limited aspect in terms of the function of the judiciary. They can only come in place after the law has been enacted and signed by the president. Second, a question would also be asked, out of these 8 bills that are now acts, why has a lot of attention been given to the Computer Misuse and Cybercrimes Amendment Act? The reason, in my view, should be one, or ought to be one. Freedom of expression is at the center of a democracy. We are here because of freedom of expression. We are here to express ourselves. And I believe that's why lawyers have given a lot of attention to the cybercrimes law, because even for us to have a discourse on the rest of the laws, including the Privatization Act, the Land Laws Amendments, we need to be given such a platform, online or offline, to actually deliberate on that issue. So anything that touches on limitation of freedom of expression comes to the foremost as a democratic nation, because without that freedom, there's nothing else you can deliberate on. So I'll come to the question I've been asked by my fellow panelists. It has been very confusing. I've heard statements by politicians, I've heard statements by lawyers, I've heard statements by the public about what exactly has been amended. So that's what I'll try to clear. There is the Computer Misuse and Cybercrimes Act of 2018. This is a law that was enacted in 2018. And then recently there is the Computer Misuse and Cybercrimes Amendment Act, which was now enacted recently. As it has been explained by a previous panelist, an amendment act comes to amend a mother law. So when you talk about the amendment, the Computer Misuse Amendment Act, it actually comes in force to amend the mother law, the Computer Misuse Act of 2018. And I'll say that it has been very limited and specific. A few amendments, actually the major ones that have caught the keen eyes of lawyers are actually 2. As we speak, there are 4 petitions that I know of challenging specific sections of that Amendment Act. There is one by Ruben Kigame and Kenya Human Rights Commission. There is another one by the Law Society of Kenya. I've seen another one by, those 2 are filed in Nairobi. There's one filed in Kerugoya by the Women Rep for Kerugoya, that is Njeri. And then I filed one at Kajiado Law Courts, myself being a resident of Kajiado. So I'll try to discuss the question I've been asked in the lens of those petitions. The mother sin, the original sin was committed in 2018. Hiyo kama ya Eve kukula fruit kwa garden. Hapo ndio shida zetu zilianzia. That's when the rain started hitting us. The Mother Act of 2018 is in itself unconstitutional, almost in its entirety, in terms of provisions. And what you've been seeing mostly circulating in the social media are actually provisions of the Mother Act of 2018. That act was challenged in court, I think by Katiba Institute or Kituo cha Sheria. They actually, Katiba Institute, thank you. They actually lost at the High Court. The matter, I'm told, is pending before appeal. There should be a judgment before the end of the year. which was challenging everything what you've heard about the fines. Those things emanate from the Mother Act. So when it comes to the amendment, there are two major amendments that have been flagged and actually constitute part of the 4 petitions I've mentioned that are pending in the high courts in various towns. One and most important, perhaps, is the amendment to Section 27 of the 2018 Mother Act. And that amendment, as I had the Leader of Majority in Parliament mentioning, it's an amendment which adds to Section 27 essentially 4 words: likely to cause someone to commit suicide. So what happens, as I mentioned, the amendment adds, deducts, or varies the Mother Act. So someone would ask, what does Section 27 provide? Section 27 provides that any communication directly or indirectly from one person to another that is likely to cause fear, it is gross, they use the word gross, and now they have added this term, is likely to cause someone to commit suicide, actually is an offense that, now this one is from the Mother Act, that attracts a fine of 20 million, imprisonment for 10 years, or both. So the 4 words is actually what is causing an uproar in terms of the amendment. And it's because the 4 words have enormous consequences when it comes to the crime as crafted in the Mother Act of 2018. That's why it is a high-stake litigation at the Court of Appeal, which we hope will succeed. But let me digest and try to explain the 4 words and their consequences. There is a legal provision that criminal offenses as crafted by Parliament or any other law should be very specific, in that someone who commits an act or an omission should be very knowledgeable and aware that this act is indeed a criminal offense. In that if there is a law that creates an offense that comes with ambiguity, then that offense should be shot down for being essentially unconstitutional. So when you talk about likely to commit suicide, suicide is a very serious issue. We should treat it as such. Interestingly, until 2 years ago, attempted suicide was a criminal offense in Kenya. A petition was filed under the mental health issues and discrimination, and the High Court again ruled that a question of mental health should not be criminalized. So what can make someone likely to commit suicide? What I'm talking to a member of Parliament, perhaps like Ichungwa, is very annoying. What are you telling people about this law that we've enacted? Do you know that this law, talking about this law, is likely to cause me to commit suicide? So anything can cause distress to someone and can be interpreted as likely to cause that person to commit suicide. So what they are doing, cleverly, they are broadening the law to make any act that is annoying to the government a criminal offense. So that if I post...
Yeah.
Sorry,
I just wanted to intervene.
yes.
Levi, you make a very good point that
Yes.
this is a law that is supposed to clamp down on freedom of expression.
Yes.
But there's another part of this amendment that includes the formation or more powers to a committee, the NC4 committee.
Yes.
This particular committee, I'd love for Evans to explain the repercussions of this amendment from that point of view.
I'll just finalize then.
Yeah, please.
My colleague can take over. So that is the issue we're actually challenging in court. And as we speak, the court has issued conservatory orders stopping the application of that Section 27 of the 2018 Act, in the sense that the amendment has broadened it and has made it ambiguous, in the sense that any act that annoys someone else then can be interpreted as likely to cause that person to commit suicide. That's one. I'll just mention another second very important aspect of that law. That is an amendment to Section 6 of the Mother Act that talks about the powers of the government and its agencies actually to close down websites. So it is something we call deletion. It's a very wide argument when it comes to free speech and freedom of expression. Now they give, interestingly, they give qualifications what can make the government actually close down a website. They mention terrorism, religious extremism, cultism, and pornography. This provision actually forms the substance of the petition in Kerugoya by Njeri because he has taken advantage of a specific provision of the law. I think it was mentioned before that any act or bill that touches on county governments should actually go to the Senate as the custodian of the interest of public in county governments. So what happens, this Section 6, the amendment to Section 6 provides that terrorism, pornography, and any website or online entity that promotes the same is actually liable, or it can cause the deletion of or the closure of that website. So Njeri took advantage of the fact that curtailing pornography is actually the function of the county government, and took advantage of that loophole of the law to actually get conservatory orders stopping the amendment to Section 6 of the Mother Act. That's the Computer Misuse Act of 2018. So those are the two issues. Interestingly, there are a few others that are not very controversial, but when it comes to the Amendment Act, those are the two controversial issues. The issue of the fine of 20 million and imprisonment for 10 years, it is actually in the Mother Act. And that's why I refer to the original sin. The Mother Act itself of 2018 curtails freedom of expression in any constitutional view. And we hope that the Court of Appeal will be gracious enough to uphold the law and declare a majority of the 2018 Act as unconstitutional. In the meantime, we enjoy conservatory orders as to Section 27 and Section 6 of the Amendment Act as amending the Mother Act of 2018. Thank you.